I am Palak Agarwal of Hidayatullah National Law University and currently a legal intern at LEXIS and Company. Today I'll be discussing about general exceptions to the law of torts. In law of torts, a person is liable when he causes an injury. However, the law officers provide various excuses or chances where the person who has committed the offense can justify his action or his omission. The general defenses are excuses which are available to the person committing the crime to justify his act or omission. The general defenses are as follows: voluntary non fit injuria. When a person gives a consent to be inflicted by some kind of injury, then there is no remedy for him under the law of torts. When a person agrees, voluntarily gives a consent to have some kind of injury on him, then he cannot complain when he actually gets hurt. His consent to risk and sufferings is a good defense against him. Such consent can be either expressed or implied. For example, A and B are professional boxers. They have never lost a match, but in one match, A hurts B. He gets his nose broken by A. Afterwards, he sues A for his nose getting broken by A. A can take the defense of voluntary non-fit injuria, as B was aware of the possibility that he might get hurt when he plays in a boxing match. Another case is where the plaintiff was a car driver and was the employee of the defendant. The defendant asked the plaintiff to drive a horse which both of them knew was liable to bolt. The plaintiff resisted but afterwards accepted to drive the horse due to the obedience of the order. The horse bolted and the plaintiff was it was held by the court that the maxim voluntary non-fit injuria would not apply in this case, as the task did not fall in the ordinary business of the plaintiff. The task does not fall under his ordinary course of business and he only accepted under pressure. The maxim was not apply as the consent was not given freely, and the plaintiff was entitled to recover the damages from the defendant. Private defense: a person can use reasonable force in order to protect one person and one's property from danger. If the defendant uses appropriate amount of force which is necessary for self-defense, then he is not liable for the harm caused by the act. However, in order to avail the defense, the threat should be imminent and should not be something which is the contemplation of one or is already over. For example, if I hurts J just because he thinks that J might hurt him one day, then he will be liable for hurting J. Plaintiff the wrongdoer. There can be no defense in the situation where the plaintiff himself is the wrongdoer. For example, there was a bridge which was under the control of the defendant. There was a notice board on the bridge which mentioned that it is only used by motor vehicles or small vehicles. The plaintiff was an owner of an overloaded truck and passed the overloaded truck through the bridge. As the overloaded truck passed the bridge was broken and the plaintiff was injured. The plaintiff asked for the damages, but if he had not passed through the bridge with his overloaded truck, the accident wouldn't have happened. He was not entitled to the damages. The next general defense is act of God. It includes abnormal natural causes like tsunamis, earthquakes, or exceptionally heavy rainfall. The next general defense is inevitable accident. It is an unforeseen accident which happens even after reasonable care is taken by the defendant and it is an unforeseen event, so the defendant was unable to do away with it. For example, in the case, the defendant and the plaintiff were members of a shooting party. They had went for a feast shooting. Then the defendant tried to aim at the pheasant, but the gun bullet glanced off the oak tree and injured the plaintiff. It was held that the injury was accidental and that the defendant wasn't liable. Act of third party. If there is an intervention by some new action or some new event, the defendant wouldn't be liable for the harm caused to the plaintiff. The next general defense is necessity. When someone does an act to prevent an even greater harm, then the person who does the act is not liable even if he does the act intentionally. For example, if someone pulls down a house for preventing the fire from spreading further, then he is not liable for pulling down the house. The next defense is act under statutory authority. If an act by which damage is done is under statutory authority, then it would be a valid defense and the person who has caused the injury will not be liable.